Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we're going to discuss a very interesting topic called the enforcement of contracts in India. Why do we discuss this? India is going to see over $150 billion of investment in infrastructure in the coming few years. And speaking about nothing less than 13 to 14 lakh crores which will be spent on making roads, bridges, highways, roads on the toll basis or the PPP basis. We need a lot of foreign investment for the same, and this will give rise to a lot of disputes. Is India geared up to meet that challenge? This is what we are going to discuss today, and I am a very apt person to discuss this issue. He is a person who's at the senior advocate at the Supreme Court of India, but he spent a lot of time on the government side. He was the Additional Solicitor General of India. He served from 2014 onwards for a period of 9 years. So he understands how things work on the government side, how things work on a private side, and he will share what to expect in the coming years and any changes if they are required. Let me welcome Senior Advocate Sanjay Jain. Good to see you.
Thank you, Tarun, for inviting me on your show.
Okay. At the outset, let me ask you, you see all this money coming into India. A lot of money is coming into India. India is the place where the next round of growth is going to happen. So funds from Europe, Japan, Australia, USA, they all are putting money into infrastructure specifically in India. In fact, I have also noticed that pension funds are also putting money into India in the infrastructure space. When this all happens, this capital needs certainty that if there is a dispute, it will be resolved quickly. In the past few years, the experience has not been so great because cases, arbitration takes a long time, then litigation takes a long time. In an introductory answer, could you share with me what should India be ready for? What do you think India should be ready for?
See, first of all, it is very important to assure the investor that their investment is safe so far as legal ecosystem is concerned. If one were to lose anything out of their investment, it could be for any reason other than legal. That is what I'm supposed to be addressing in this particular show, I believe.
Yes.
So, from legal perspective, what needs to be done is is strengthening our enforcement regime. Though Government of India has already opened a portal called Enforcing Contract Portal, which will go a long way in addressing the problem which is being faced. That is one. Secondly, we need to sensitize the judiciary also, because India is a vast country. Not all parts of the country you would have evenly balanced commercial ecosystem. So there may be some jurisdictions where the judges might not be aware of these sensitive nature of these kind of litigations. So now we have National Judicial Academy. So with the current Chief Justice being so proactive, one can think of some kind of orientation courses for the honorable and learned judges who can be sensitized that it is possible within the framework of the legislative regime to make the contract enforcement much more rapid and taking a path which is much more assured and result oriented. The third aspect of this issue which you mentioned is that the legal fraternity also needs to gear up to the challenge, and right from the beginning, when the contract is conceptualized, at that point in time only, the litigation strategy should somehow be inherently ingrained in the contract drafting system, so that if at all any particular project or any particular contract lands itself in that dispute zone, then the strategy as to on which forum it is to be fought. I mean, of course, if the contract has arbitration clause, the forum is decided. But suppose it has not, then then we have to see what kind of subject matter it has. Is it a subject matter of tribunals? Then accordingly, we have to work out a strategy. So the legal fraternity also needs to be fairly sensitized and fully geared up to meet the challenge.
One thing I want to know from you, you are someone who knows both sides. For decades, you have worked as a private practitioner. Then you became the additional solicitor general. You have defended the government and the PSUs on thousands of crores worth of disputes in these 9 years. Now you're again back to private practice. So you understand both ends. What does the client need to keep in mind, according to you, when he is investing in a PPP project, when he is entering into an infrastructure project in India? A, from arbitration litigation point of view, what the client should know. Second, what should be his strategy? Because let us take it for granted that if not big, small disputes will happen. It can even be with their own subcontractors. That also happens. Could you explain it for the benefit of somebody who's investing in India, Indian investor or foreign investor? Could you explain this?
You see, primarily the strategy will be guided by the nature of the business activity. If it is very highly capital investment oriented, where the capex is more, then given the complexity of the matter, it may be preferable that there should be an arbitration clause and one should go in arbitration, because arbitration gives that platform an option that by way of interim reliefs, the client can immediately approach the court without any loss of time and get some kind of an interim relief without going through the rituals of preparing a complete suit and then asking for an interim relief, because arbitration gives you that option, that without the arbitration actually being kicked into motion, one can go for an interim relief. So that is one. So it depends, as I said, depends upon the nature of activity. If your investment is very high, then the time is very important. The timely relief is very important. The second kind of scenario, as you said, that if there are like smaller contracts with vendors, there is no need. One can go for a hybrid model. I mean, for large stake issues, you can go for arbitration clause. In other kind of contracts, one may not have arbitration clause. There, the civil courts may be a better remedy, because the complex issues, or if there are a large number of witnesses.
So what I want to know, that the legal strategy that a lawyer designs is very important when you want a dispute resolution, because many times if the legal strategy is bad, even if you have a good case, you may lose it with the government, because the government is a very strong litigant. He's got an army of lawyers, and who better than you know, you are an ASG in the government of India. Where do you think that things can go wrong, and what kind of strategy works?
See, so far as the strategy is concerned, again I say that it is the subject matter oriented.
Right.
Suppose one is going for a very large project of national importance, say it is infrastructure or some power plant or something which concerns the basic aspects in which the country is hugely invested. Keeping that in mind, the strategy should be, so far as the government is concerned, to seek resolution without litigation.
Okay.
To begin with. So if, and the government has a large number of schemes, the government encourages now the discussion and a solution without litigation. So it is a kind of a mediation or a pre-litigation mediation, which is also an integral part of our dispute resolution regime.
So even the lawyer needs to advise this properly to the client, that for these disputes, do this and...
Yes, absolutely. In fact, if we see most of our arbitration clauses, they also bring the arbitration as a second stage recourse. As a first stage recourse, what is suggested or recommended is resolution through negotiation or discussion, a conciliation effort. If that should be taken very seriously, and at the government level and at institutional level, because industry also has its own associations, chambers and associations, industry specific associations are there. So there are a large number of institutions. So at institutional level, at government level, there should be a very dedicated effort to make conciliation regime very strong. Right now, we are all focusing on litigation aspects. The moment there is a dispute, the first thing which comes in our mind that we should rush to a litigation. We should rush to a court or a tribunal, as the case may be. But then that has its own pitfalls, because the moment one party rushes to the court, the other party says that all right, now the swords are drawn, we will see.
So
we will
this
take
is
it to
where
the logical
you need a
conclusion.
right lawyer to advise you. Is this the place where instead of pushing you into a litigation, he should advise you that how to solve this in the quickest time?
Absolutely.
In India, one thing, I find this in any big project, wherever somebody has put in thousands of crores, a group of interested parties of civil rights activists will come and file PILs. They may have got nothing to do with the business. They may not be staying in the area where the business is running, but they will file a public interest litigation, and then somehow the project stops. In PPP projects, tolling may be stopped. So then the companies, these days courts are very tough. They don't entertain frivolous PIL. We have seen that sometimes costs are also imposed. Some judges have gone and imposed cost of 40 lakh, 50 lakh also. And in fact, judges also ask about the intent of the PIL filer, that what is your intent behind. But still, there is this element of frivolous PILs against industry. And big projects are targeted. Big numbers are put to scare the courts, saying these many crores the company will benefit. So when there is a commercial transaction, the courts need to look at it commercially. Point number one, that if big numbers, these are big numbers, big companies put in big money and earn big profit, that's how people invest in your country. Secondly, the numbers are played out in the media to attack the company. So much of money, not realizing that when you take loans at 10 and 12% interest rate and invest thousands of crores, the gestation period to recover the money and also your profit takes a lot of time. And if one company fails to recover its cost, 10 other get scared. So India suffers. Can you explain how to avoid falling in the trap of these PIL people, and if you fall, how to get out of it?
Yes. Tarun, you are absolutely right in saying that in this country, public interest litigation as a vehicle of ensuring justice to the larger number of people has been misused, and in many a case we see that it is a publicity interest litigation or a personal interest litigation, which is the correct abbreviation of PIL in those cases. Be that as it may, I am in complete alignment with you when you say that some of the courts have come down heavily. But the point is that for a court to come down heavily, it will still take some hearings. Some amount of dates would be consumed in it. And by the time the court realizes that it was a frivolous litigation, a vexatious litigation, which was being done as a proxy litigation on behalf of somebody else, or by some individuals who are actually put up by NGOs also, because there are some NGOs in this country who get foreign funding to ensure that the development activities in this country are impeded in some way or other. But the government in the recent times has taken enormous steps in controlling the funding of those frivolous NGOs, etc. So that is one aspect which is also already being done at the administrative or government level. But coming to the issue of tackling it in the court, it is extremely important that on the very first date of hearing, when the matter is listed, there should be an effort to accumulate maximum amount of material rather than easily accepting a notice and going for that filing a counter regime, because in some ways a lot of lawyers are very conventional. I would, as a ASG, it was always my intention that if I found that a litigation is frivolous, I would be aiming to get the petition dismissed on the very first date. So this is what I would recommend or request everybody in my fraternity, that the idea, so far as PIL is concerned, one should be able to assess it very quickly, and one should be able to accumulate and assimilate the material and inform the court on the very first day. That is one. Secondly, the greater responsibility, or I would say in equal proportion, the responsibility lies with the judiciary, because they, the most often the expression that there is one, 2 or 3 lines which are there in almost every order. It's like a platitude. No order as to costs. Now this no order as to costs is something which may befit a situation where the litigants are poor, or it is an uneven battle. But in a matter of commercial connotation, if the petition is found to be frivolous, then why is the case that there is very little cost imposed or no cost imposed? So this there should be a change in the mindset in the imposition of cost. Every frivolous litigation should be visited with heavy amount of cost, and even if we are not confining ourselves to the PIL, and we are contemplating even suits which are filed in different courts, some of them are equally frivolous. In that case, one has to go and resort to the sections of cost like 35, 35A, 35B of the CPC, or in commercial court acts there are provisions, equivalent provisions. CPC restricts the quantum to a very small level of 3,000, which is almost ridiculous. In commercial court enactments, the courts have been empowered to rationalize the cost and grant it. But still, there is a lot to be done at legislative level to empower the courts like civil courts, because constitutional court has an inherent power under the constitution to do complete justice, so they can impose any amount of cost. But civil courts, where a lot of litigation goes, are sometimes feeling handicapped that, look, how can I impose such a heavy cost? So therefore, there is a need for legislative amendments in the relevant procedural laws, that the civil court should be empowered to impose a greater cost. So that will be another way of controlling the frivolous litigation. And the third suggestion that I would give in this regard is that there should be some kind of a profiling of these litigants whose petitions have been found to be frivolous, and there should be some kind of a circulation of the number of cases that they have filed and which have been found to be frivolous. So at least the stakeholders are aware that this is the situation, because if you are in, like it happens, we are able to point out to the court that this person is a habitual litigant and he has been filing petition after petition, and most of them have been found to be frivolous. So then it will give an extra ammunition at the hands of the suffering party or the business entity, which is the targeted victim of that litigation, because usually all these public interest litigations do not directly always target a particular business entity. They show that it is a cause in public interest, and all those who are standing on the other side of the fence are some kind of villains in the cause. So therefore they are indirectly hitting them. So there should be a proper database with every business entity of this nature, that they should keep a database in their office, that what kind of frivolous litigations are being filed, particularly pertaining to their industry, in which particular state their factories or their business establishments are located, what are the local concerns in those areas, and who are the persons who may be found to be coming to the court and dragging them. So therefore, in a legal manner, if you can create a database, then you are better prepared, and you can also do some kind of a course correction, that if something needs to be done to avoid those kind of litigation by being sensitive to the feelings of the local people. Suppose one is engaged in some kind of an activity, or one is coming out with an advertisement which offends a particular class of population. So one should avoid that, because usually what happens is that when there is an opposition, it may be a bouquet of various factors, not just one factor. So the prudence lies in analyzing these kind of frivolous litigations, not with disdain, but with proper amount of research as to why did they happen in the past and how can we control and avoid them in future.
Point very well taken. One thing that I also discussed with you was about the Specific Relief Act. Why do I discuss this? That infrastructure projects have long gestation periods, 30 years. You will invest money in 2000 and the final tolling will happen in say 2032, 33. In this 30 years, there is immense possibility of some PIL happening, some litigation happening. Do you think that Specific Relief Act, to avoid stalling these kind of projects has been underutilized? What do you feel on that?
It has definitely been underutilized, Tarun. Despite the amendment in the Specific Relief Act, which has brought Section 20 capital A and another section in Section 41. Section 41 deals with those instances where injunction cannot be granted. So there we have now section small h, small a. So these two provisions collectively advise the courts that so far as infrastructure projects are concerned, or other certain, there is a schedule there, that if these are the subject matter of the litigation, in the ordinary courts, unless some grave injustice is likely to be done, one should not grant injunction in those matters. But unfortunately, what has been seen is that either the courts do not take cognizance of the existence of those provisions in the Specific Relief Act when they pass the interim orders, and it is further seen that there is also a provision, and there is a judge-made law also on this point, that if somebody has come seeking a relief that a large public importance project or an infrastructure project be stayed, it is possible for the court to say that, all right, before we entertain your request, are you willing to deposit X amount as a security, so that if your litigation is thought to be ultimately found to be false, then that amount you will lose. So there has to be this kind of a proactive application of these provisions which are available within the legislative domain, that the court can ask for a security from the plaintiff. Court can ensure that without inviting the defendant in the infrastructure project, howsoever big the allegations are, ex parte orders may not be passed. So if ex parte orders are not passed in these kind of projects, then there will be a much better environment for these investors who invest in a huge amount of money in the projects of national importance, in the projects, in the infrastructure projects, in power projects, or other projects of this nature. And in fact, very recently, in a particular case, not exactly on this point, but Justice Chandrachud, in a matter pertaining to solar energy, solar power energy, visualized, he mentioned it very categorically, that think of the plight of a woman and a child who are struggling to cook their food with the traditional system of chula, and they do not have any source of energy, but like they are in that part of the country where sun is in plenty. So if there is a huge solar power project which is being contemplated, then in such a case, I tell you the name of the case is M.K. Ranjit Singh versus Union of India,
Yes.
in which Justice Chandrachud pointed out that in these kind of projects, it is very important to ensure that they are not impeded in any manner.
Okay.
So there is already a judicial awareness in this regard that the project of national importance, large, because project, when we say project of national importance, ordinarily it means that they are capital intensive projects. Because in such a huge country, if you are talking of a project of national importance, it will inevitably involve a huge amount of money, a large capital investment. So there, if there is, without a proper application of mind, for no rhyme or reason, there is a stay order, and that stay order continues for years together, because the courts may not get time to hear the argument at that length in a matter so complex, then what happens? Then the cost of interest and all other attending costs, because the manpower cost, the cost of assimilating the resources, mobilization, the capital mobilization, all these added together, it results either in a huge loss to the investor, and many a case the investor may go back. He may just wind up the shop and go back.
And that has a ripple effect on other
ripple effect. And so many people who would have got the employment, they are unable to get employment. And so many people who had co-invested their money get
banks finance,
and the banks also lose. And then what you ultimately get is a NPA account, and then that brings bad name to the bank, and that brings bad name to the country.
One final question I want to know from you here. Do you think that if the case is explained well, even if big numbers are thrown in thousands of crores, the courts are able to appreciate in India a fact that as India grows, numbers will be big. Each project will be 4,000, 5,000, 8,000 crores. Yes. And they do require what you can say, return on investment. Yes. It's a very valid, for anybody who invests, return on investment is a reality. How will he invest money if he is not guaranteed? And when the time of return comes and there are cases, if courts don't appreciate, then it leads to a negative sentiment. Do you think courts are appreciating that?
I think I would put it on a positive note. I think the courts do appreciate that in civil matters, big numbers is not a taboo. In civil matters, if there is a big number, it only shows that there is a huge amount of investment that has taken place for a particular purpose, and the matter is serious. And the courts who are commercially trained, they do appreciate that if the amount is large, the matter requires a hearing at a preference. The big numbers become taboo only when there is some fraudulent angle involved in a matter, and the matter reaches criminal courts.
Otherwise?
Yes. So otherwise, in criminal courts, the big number sometimes acts to a disadvantage.
But not in commercial.
But in the commercial regime, big numbers are no more a disadvantage, because pecuniary jurisdiction, the way it has been structured now, that the matters up to a particular amount, they remain with the lower judiciary, that is, though it's not a very happy expression, the civil judges. Yeah. Then a matter from that particular level to the level of particular figure, they go to the higher judiciary. And in most of the country, because original site is there only in very few high courts like Delhi, Calcutta, Bombay, Madras and Himachal Pradesh. Other high courts do not have original site. So there it is the district judiciary only which handles the matters up to any amount. So therefore that crystallization or that segmentalization is already done in terms of pecuniary jurisdiction. And the judges at higher level are much more acclimatized, much more familiar and much more sensitized to appreciate that these numbers are ultimately for the benefit of the country and for they are very important for generating the employment and the business environment in this country. So this awareness is coming, but lot needs to be done, Tarun. It is still not at that level where we can say that we have reached a satisfactory stage. We need to, it is a continuous process. The successive chief justices of the country need to keep this aspect in their minds, and through the National Judicial Academy at the High Court level and through other academies, the training. There is a extremely important. For instance, you have so many intellectual property rights, and they are very complex or technical subjects. Some of them are relatively easier, but in many jurisdictions, the district judges also do not have any exposure of those kind of laws. So then what do? They treat it like a normal civil suit, and they grant injunctions without appreciating. So that becomes a huge tragedy. So this is
training of judges is also
training of judges is extremely important. Though the judges may get offended that who is we are already so experienced, you want to train us, but then every person, I mean all great lawyers in this country, all great judges in this country have always said that we are students. We are students. I mean, if you see the doyens like Mr. Nariman, he always maintained that he is still learning. So that kind of attitude be there.
It was a pleasure talking to you today on infrastructure. This is what all promoters, general counsels, people who invest in companies in the infrastructure sector, be it pension funds who invest in India, they are all looking towards Indian courts because disputes are a reality. They will happen. It's a foregone conclusion but they all need quick resolution. Yes. And this talk indeed was enlightening in many ways. I appreciate that you could join us today for this. Thank you so very much. Thank you. So you saw Senior Advocate Sanjay Jain. He explained to you the various intricacies in infrastructure projects litigation, how it has to be solved. It also helped us because he spent time as the Additional Solicitor General of India earlier. Now he's in private practice, but he gave us views from both ends and how it is important for infrastructure companies. Like he highlighted the issue of pre-litigation mediation, how to avoid litigation first in big infra projects and solve it before it goes to that stage. That also was a very important fact. Right legal advice is what he stressed on, that when there are big infrastructure projects and disputes are there, you need the right legal advice to solve it very quickly so the project can go on. We will continue this discussion with him in our next show, but that's it for now. Thank you so much for joining us. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.